Please note that this webinar is providing general information only, and no content should be construed as legal advice or that of an attorney-client privilege relationship has been formed. We can now begin our program. Today's speakers are Doug Isenberg of the GigaLaw firm and Craig Schwartz of fTLD Registry Services. Doug Isenberg is an attorney and founder of the GigaLaw firm and is a pioneer and recognized leader on Internet law, a domain name arbitrator, a frequent author and speaker on Internet legal issues, and an adjunct professor of computer and cyberspace law. He wrote the GigaLaw Guide to Internet Law, published by Random House in 2002, which is the definitive text on Internet law. Doug has worked with clients on domain name transactions and disputes for 20 years, and today represents some of the world's largest and best-known brands with respect to their Internet legal matters. He also serves as a domain name panelist for 4 of the world's leading dispute providers, including the World Intellectual Property Organization and the National Arbitration Forum. Our second speaker is Craig Schwartz, Managing Director of fTLD Registry Services, the .bank and .insurance domain names, and is responsible for developing the organization's strategic response to ICANN's generic top-level domain GTLD program, and he leads the team in achieving fTLD's mission and objectives. Previously, Craig served as ICANN's chief GTLD registry liaison. The fTLD Registry Services, founded by leaders in the financial services community, is owned, operated, and governed by banks, insurance companies, and their respective trade associations around the world. fTLD was granted the right to operate the .bank on September 25, 2014, and the .insurance on February 19, 2015. All applicants will undergo a thorough verification process before being awarded a domain and must comply with strict regulatory registry processes. I'm now turning the program over to our first speaker, Doug Isenberg.
Great, thank you, Carol. I'm very happy that everybody is with us today, and Craig and I look forward to talking about the topic of cybersquatting and the financial services industry. Just to give you a quick overview of the topics that we'll be talking about today, and hopefully these will proceed in a fashion that makes complete sense. But just to begin and ensure that we are all on the same page, I will provide a little bit of background on the history of cybersquatting and domain name disputes generally, and then talk about the particular impact that we've been seeing in recent years and right now on the banking and financial services industry. Then we'll move into talking about domain name disputes in the financial services industry, in particular with respect to what are called the legacy top-level domains, such as .com and some of the country code top-level domains. These have historically been fought through a process involving the UDRP, the Uniform Domain Name Dispute Resolution Policy. Then Craig will provide us with some very useful and helpful information about 2 important top-level domains that his company is responsible for as the registry operator, .bank and .insurance, and how you can participate in those. And then finally, I will focus on some of the new top-level domains and how they are impacting the banking and financial services industry and the new mechanisms that are in place, including a relatively new dispute policy called the URS, or the Uniform Rapid Suspension System, and how it can tackle these issues. And then finally, we hope to leave a little bit of time at the end of our program for some questions and answers. So just to be clear, if you have been paying attention to the news at all in recent years, in recent months, and recent weeks, it is obvious and called, and obviously you have an interest in these important issues. The headlines are full of problems that the banking and financial services industries are fighting online. It seems like we hardly go a day without hearing something about these topics. Not all of them are related to cybersquatting, but certainly domain name issues are a very important part of many of these challenges that the banking and financial services industry is facing online. So just to be clear, what is cybersquatting? In general, generally speaking, cybersquatting, as you can see here, is the registration or use of a domain name that is confusingly similar to someone else's trademark without permission in bad faith. There are a number of definitions there that will become important throughout the process of fighting cybersquatting. But there are primarily two important tools, at least for those here in the United States. The Anti-Cybersquatting Consumer Protection Act, or the ACPA, is a revision to the U.S. trademark law that is specifically intended to address the issue of cybersquatting, at least in certain circumstances. That is, when a domain name registrant has a bad faith intent to profit from a domain name registration, including by intending to divert consumers. The ACPA, however, has not proven to be particularly popular, in part because of the UDRP, the Uniform Domain Name Dispute Resolution Policy, which is a very important and popular tool for fighting cybersquatting. This is designed to attack registration and use in bad faith, including instances in which a domain name registration creates a likelihood of confusion. In just a moment, I'll walk through a little bit more detail about what that means. But first, I wanted to point out how important the UDRP is with respect to some particular domain names that you will probably recognize, or at least you'll recognize trademarks within these domain names in the banking and financial services industry. All of these domain names that you see on the screen here right now that include, such well-known trademarks as TD Bank, Bank of America, Morgan Stanley, Wells Fargo, and so forth. I'll talk about all of these as the presentation goes on, but all of these are actual domain names that at one time were registered by cybersquatters and have been the subject of domain name dispute proceedings initiated by trademark owners, primarily through the UDRP. The UDRP, as I mentioned, is the most popular tool for fighting cybersquatting, both in the banking and financial services industry and generally speaking. The UDRP was created by ICANN, the Internet Corporation for Assigned Names and Numbers, and launched in 1999. It is an alternative to going to court through formal litigation, and it is relatively quick and relatively less expensive than traditional trademark infringement law or even a proceeding under the ACPA, the Anti-Cybersquatting Consumer Protection Act that I mentioned before. The UDRP applies to .com domain name registrations, as well as all of the legacy or traditional GTLDs, .org, .net, and so forth. Some of the CCTLDs, the country code operators, have voluntarily adopted the UDRP or a variation of the UDRP. Some CCTLD operators, by the way, have a different domain name dispute procedure entirely or none at all. But because it is relatively quick and inexpensive, the UDRP, as you can see, has been labeled the preferred option for most trademark owners a number of years ago by Corporate Counsel magazine. So what's required under a UDRP proceeding? Essentially, a trademark owner, whether you're in the banking and financial services industry or any industry for that matter, you are required to file a complaint if you want to obtain the transfer of a domain name, and in that complaint show the following three elements. Number one, that the domain name is identical or confusingly similar to a trademark in which you have rights. Number two, you have to show that the registrant of the domain name has no rights or legitimate interests in respect of the domain name. And number three, you have to show that the domain name has been registered and is being used in bad faith. The number of domain name disputes under the UDRP has, as you can see from this graph, generally been increasing through the years. The two lines on this graph show the number of domain name disputes at WIPO. WIPO is the World Intellectual Property Organization, which is one of the 4 appointed by ICANN UDRP dispute resolution service providers. In addition to WIPO, the National Arbitration Forum, the Czech Arbitration Court, and the Asian Domain Name Dispute Resolution Center all provide UDRP services, but WIPO is the largest of them, and the only one, by the way, that publishes relatively real-time statistics. So the two lines on this graph indicate both the number of cases that have been filed with WIPO through the years since that first dispute in 1999, and then the actual number of domain names in those cases, because it is possible under the right circumstances to include multiple domain names in a single UDRP complaint. This next slide shows the same type of data from the forum, formerly known as the National Arbitration Forum in Minneapolis. Again, the number of UDRP cases that have been filed and the total number of domain names, which saw a significant increase in the past year. So WIPO, and by the way, through the course of time since the UDRP went into effect in 1999, nearly 88% of all UDRP disputes have been decided in favor of trademark owners. When you file a UDRP complaint against a domain name that is problematic, you can request either that the domain name be transferred to you or canceled in either event, such that the domain name, the current domain name registrant loses control of the domain name. So as you can see, in the overwhelming majority of cases through the years, trademark owners in both the banking and financial services industry and all industries generally have prevailed in close to 88%. But as this slide makes clear, the banking and financial services industry is actually the second most popular, if you will, filer of these UDRP domain name dispute complaints. This data is based on WIPO's report for 2015. Banking and financial services industry is second only to the fashion industry when it comes to filing UDRP complaints. This is a list of some of the entities, banking and financial services companies worldwide that have filed domain name dispute complaints with WIPO in 2015. As you can see, it's a pretty international or global listing. Some of these you may recognize and some of you may not. I know we have a largely US-based audience on the webinar today. At the forum, which perhaps seems to attract more US-based complainants, our US audience probably will recognize more, if not all, of these domain names, including American Express, Bank of America, Barclays, and so forth, that were among the filers of UDRP complaints at the forum in 2015. So in a few minutes, I'll transition the presentation to Craig Schwartz, but first I wanted to talk about a few real-life domain name disputes so you can have an understanding as to what some of the issues are that the banking and financial services industry have been facing. You'll probably recognize most of these brands as I go through several real-life examples. Wells Fargo, for example, has faced or initiated a number of UDRP complaints through the years, including one just last year for the domain name wellsfargo.com with an extra letter I stuck in between the two L's and Wells. This is a common tactic by cybersquatters to actually typo squat. That is, to create a domain name that is a variation of somebody else's trademark, perhaps based upon simply a typographical error that anybody might make when you're typing the address, when you're typing the domain name into the address bar. In this case, Wells Fargo alleged that this domain name, wellsfargo.com, was being used in connection with a website that really was designed as a near identical copy of Wells Fargo's own website as part of what you're probably familiar with is typically described as phishing activity. At some point during, either before or during the UDRP proceeding, the registrant of the domain name actually deactivated the website, and so there was only a parked page, if you will, that was associated with it. But the respondent, the registrant of the domain name, did not file a response in this case, and the UDRP panel in this case easily found bad faith, even citing a previous Wells Fargo decision from nearly 10 years earlier, noting that past panels have held that phishing for information, for financial information through a disputed domain name indicates bad faith. The next case to spend just a minute on involved Lloyds Bank, internationally known, and the owner of many trademark registrations that consist of Lloyds Bank. Interestingly, this domain name from this dispute, also from last year, did not contain the entire Lloyds Bank trademark, but contained what the panel referred to as the dominant or most distinctive trademark element, that is the Lloyds name, plus the words privatecommercialfinance.com. In this case, the panel said that the substitution in the disputed domain name of the trademark element bank by the generic and related elements private, commercial, and finance does not avoid a likelihood of confusion. This was a case also in which the domain name Lloyds privatecommercialfinance.com was being used apparently in connection with some type of phishing activity. And as a result, the UDRP panel ordered the domain name transferred to Lloyds Bank. The next dispute I wanted to just spend a minute on from earlier this year was brought by Comerica Bank out of Dallas, Texas, involving the domain name my-comerica-alert.com. This also, according to the domain name dispute, seemed to be a type of phishing scam, and the panel in this case also found it rather simple to award a transfer of the domain name to Comerica, noting that the phishing attempt was an attempt to deceive Comerica's customers. A couple more quick slides, and then we'll move on to learn a bit about .bank and .insurance. But this is also a very clear example of typo squatting. Capital Bank uses the domain name capitalbank.com, and the disputed domain name in this UDRP case was capital with 2 L's, bank.com. Again, a type of phishing site. This was a dispute at the National Arbitration Forum from a couple of years ago, and in this case, the decision pointed out that the domain name was used to operate a phishing website designed to obtain sensitive personal and financial information from the bank's customers. And then finally, this is a very old case, actually from the year 2000, the first full year of the UDRP, but I wanted to mention it simply because not only does it involve a well-known entity in the banking and financial services industry, Bank of America, but it involves a tactic that we're starting to see arise again with the new GTLDs, and that's inclusion of www at the beginning of the domain name itself. Not simply in the URL, but this domain name was actually www.bankofamerica.com. It is a tactic that cybersquatters find helpful. In this particular case, the cybersquatter was simply redirecting the domain name to a website that displayed banner advertising and other commercial content. And this decision from the year 2000 from the National Arbitration Forum, the arbitration panel ordered this domain name transferred to Bank of America. So at this time, just want to take a quick pause, and we will launch a poll here to hear a little bit about your own experience with domain name disputes. And you should see on your screen in just a moment a quick poll question asking if you have ever filed a domain name dispute complaint, or do you anticipate having a need in the future. If you could just go ahead and make your selection here quickly, and in just a moment we will show the results. right, still have a couple of responses coming in. And we will go ahead and close the poll here. And as you can see, for those on the call, at least, we have an amazingly equal number of those who have said yes and no, 38% each, as to whether you have actually filed a domain name dispute complaint, and 24% of you are unsure. So with that said, at this time, I will hand the controls over to Craig Schwartz.
Doug, and thanks to GigaLaw for having fTLD on your web today to talk about .bank and .insurance. Doug, if we could get back, there we go, to the slide deck.
Yep.
While we're transitioning over, let me first start by saying that a lot of the ills that Doug's talked about, and specifically cybersquatting, are some of the reasons that fTLD Registry Services was created, and the reasons that we chose to apply for .bank and .insurance. And as you can see from the screen, the internet financial world is changing. There are many, many options now available to, whether it's financial services or more broadly, new internet web extensions to choose from. And here are just a selection of those that are geared towards financial services. The shapes in green are the TLDs that we operate at fTLD. Those in blue are known as branded or corporate domains that are run either by businesses and or trade associations. And then the red boxes, or the red shapes, are examples of other financially oriented generic names that you should be aware of when you're planning your domain name strategy. And Doug, my slide is not advancing. Thank you so much. So fTLD Registry Services is a private company formed in 2011 by the financial services sector, a coalition of banks, insurance companies, and trade associations. As Doug shared at the onset of the webinar, it was our strategic response to ICANN, or the regulator of the internet space, and their unbounded expansion of the top-level domain space. And as you can imagine, banks, insurers, and the like were very concerned about what an unlimited number of new web extensions would mean in the way of potential customer confusion, more brand infringement, which is a lot of what Doug has talked about, and also just increased costs in having to maintain domain names and lots of new TLDs. We are here to serve and protect the insurance and banking sectors, and we are owned, operated, and governed exclusively by the financial services industry. While we are a private company, we operate very much like a trade association and are focused on ensuring that these namespaces are operated in a trusted and protected manner and to serve the sectors. Next slide, please. So some basic statistics and status on where we are. So what makes our TLDs different than almost every other internet web extension? And that is the strict way that it's operated, and that is the eligibility requirements, that is who can register what domains and how can they be used. We do require mandatory verification and re-verification of eligibility to ensure that if you get a domain name in .bank or .insurance, that you are qualified to have it. And we do mandate a host of security requirements that are intended to take a big bite out of a lot of the ills that are happening online, whether it's website redirection, whether it's data hacking and data tampering, whether it's phishing or spoofing. What we've done via these security requirements listed here, but also a number of others, is a way to make these spaces a much more secure option than is currently available in other top-level domains. Next slide. So looking at our policies and requirements, Here you can see who is eligible in the insurance and bank TLDs. It is largely for regulated entities, but as you can see, there are a number of other categories of participants who are eligible. If we look at how many names have been registered in .bank so far, I would say 99.5% of them are banks, and the other 0.5% are trade associations and a couple of service providers. And for .insurance, given we just launched last week, it's still a little bit early to tell with those numbers, but we'll get there. Next slide. Moving on to our name selection policy, which is yet another way to ensure that domain names are only getting into hands of entities that have a right to have them. During the qualified launch program in the Sunrise, entities can register only an exact match of the registration they made in ICANN's Trademark Clearinghouse, and thus if the registered mark is the best insurance company in Europe, then the only name that could be registered during Sunrise is the best insurance company in Europe .insurance. Probably not very desirable, but that's the way the Sunrise period works. When we move on to founders and general availability, our rules are slightly more relaxed, and we say your domain name must correspond to your trademark, your trade name, or your service mark. And that is, again, to ensure that if you are not Wells Fargo, you're not going to get a Wells Fargo.bank domain name. And to protect the integrity of the space and to protect the banks and the customers and the insurers that participate, and to guarantee that when you get to a .bank or a .insurance domain name or website, that you know you are where you're intended to be and that you can trust that information. Next slide. We say that registered trademarks are not required in the founders and general availability period. However, you must be able to demonstrate a right to have that name, which could be if you're in a country that recognizes common law rights. That would be adequate to secure a domain name. Most registrations will be made during general availability because of the flexibility in the naming convention. Again, that corresponding rule. And names cannot be registered that correspond to those on fTLD or ICANN reserved names lists. Those names are all published on our various websites at ftld.com, register.insurance, and register.bank. Next slide. So I'd like to spend a little bit of time talking about the verification process because it can be complicated if not understood properly, and it really is the core, or one of the cores of the integrity of the .bank and .insurance domains. If you're familiar with the process for certificate authorities that issue extended validation SSL certificates, that's where you get the green browser bar when you're at a site that is secured with an EV cert. What we are doing is modeled after that industry standard. We have contracted with a company called Symantec, who is a leading industry player for internet security and authentication, to perform that function for us. And during the registration process, your registrar or the authorized retailer you go to purchase domain names from will collect a host of information from you. And it's really important to understand that if you're a regulated entity, we need to know who your government regulatory authority is. And we also need to know your regulatory ID number. Again, your registrar will ask that information of you. With respect to your legal name, address, and phone number, it's important that you provide the exact name of the corporation that's seeking to register the domain name, as well as their primary business address and their primary phone number. Symantec uses a system of what they call qualified independent third-party databases, such as Dun & Bradstreet or regulatory databases, to verify that the phone number provided, for example, in the order, actually corresponds with the phone number of the organization seeking to register a domain name. So those are very important details. Next slide. Thank you. Back one, please. A little bit more about the verification process. So what do we verify, or what does Symantec verify, and then pass on to fTLD to confirm? And that is the entity eligible? That is, do they qualify as one of the categories of registrants that we have put into our registrant eligibility policies? We verify that the contact is a full-time employee of the entity and that they're authorized by the entity to register domain names on its behalf. Again, multi-levels of protections to ensure that domain names are only getting into hands of authorized entities and authorized individuals. We also do check that domain names are compliant with the name selection policy. Again, does it during general availability correspond to your trademark, your trade name, or your service mark? An important part of the process is that Symantec is going to call the organization using the business's legal phone number that was provided during the registration process. And that phone call is to ensure that all of these requirements above in what is verified have been met. And that is specifically, is the registrant contact a full-time employee? They will check that, and they'll also check on the authorization piece. And they're not going to check on authorization with the person who requested the domain name, but rather likely someone in the HR department, or perhaps the registrant's contact manager. And usually verification can be completed in just a matter of days. Next slide. So we frequently have questions about how do I meet the security requirements and who can help me with this. And there are a handful of fTLD approved registrars that have created security packages that for a fee will sell that to you and help you meet the requirements. We do encourage you to check with the different registrants about the services and compare prices, because they do all charge slightly different prices based upon their business model. Your website hosting provider may be able to help you meet the requirements, as well as your technology service provider or your DNS service provider. So a host of potential third-party partners that can help you meet various elements or all of the security requirements to participate in .bank and or .insurance. Next slide. Another frequent question we get is, what does it cost? And it's important to understand that fTLD is responsible for setting the wholesale price to all of its registrars. It's inclusive of the verification fee, and every registrar pays the same price for a domain name when it purchases it from us. However, registrars are in the business of making money, and they will set their retail price based on a variety of factors. Most frequently, it's what other products do they sell to you during the domain name registration process. It could also be that they offer discounts if you register certain quantities of names, or perhaps if you register names for certain periods of time. So again, it's important to shop around, be sure you understand the fees, understand what you're getting into, and carefully select your registrar. Next slide. So we recently started doing interviews with banks that have.
Great, thanks very much, Craig. That was excellent, and actually provides some encouraging information or a little bit of encouraging news about the new GTLDs, since that's not always what we seem to be hearing about these days. So a quick poll question as we move on here. If you could take a look at your screen right now, and you should see the question on your screen asking if you have registered or do you plan to register a domain name in a new GTLD, whether it's .bank, .insurance, or any of the nearly 1,000 others that have launched so far. So we'll keep the voting open here for just a minute and then share the results. All right, it looks like all the voting is in, so we can share the results here, which are interesting. 57% of those on this call have registered or plan to register a domain name in a new GTLD, and only 17% say no. So that's a perfect transition, if you'll bear with me for just one quick technological moment here while we advance the slides. Excellent. So really what Craig was talking about with .bank and .insurance and what the poll question was getting to is the new GTLDs. As I said just a moment ago, we now have nearly 1,000 of them that have been launched in the past couple of years. Some obviously have proven to be more popular than others. And with the new GTLDs, we've seen the creation of a new domain name dispute process, the URS, the Uniform Rapid Suspension System. This was just launched in 2013, and it applies to the new GTLDs, such as .bank and .insurance, although frankly it will be quite surprising, I'm sure, to everybody if we see real disputes there. But we already are seeing them in many of the other hundreds of others that have been launched. The URS does not apply to .com or, generally speaking, the legacy GTLDs. As I mentioned earlier, the UDRP, which does apply to .com, is a quicker and less expensive alternative to litigation. The URS can be seen as a quicker and lesser expensive alternative to the UDRP. But it's only available in certain cases. Again, not only does it apply only to the new GTLDs, but it's intended only, as you can see here, for use in proceedings where there are no open questions of fact, only clear cases of trademark abuse. And the remedy is probably one of the most interesting pieces of the URS. As I mentioned earlier, under the UDRP, a company, a trademark owner, whether banking and financial services entity or otherwise, who files a UDRP complaint, can get the domain name transferred to it. And under the URS, the domain name is simply suspended, and that suspension is only temporary. It's for the life of the registration with the possibility to extend it for one additional year. In addition, there's actually a rather complicated appeals process that's built in to the URS, which is not true of the UDRP. But it is, as I said, even quicker and less expensive than the UDRP. So the URS has not proven to be, oh, pardon me for just a minute, as it seems the slide is off here. There we go. The URS has not proven to be nearly as popular as the UDRP, despite the fact that it applies to many more top-level domains and is even less expensive and quicker. The forum, the National Arbitration Forum, is the most active provider of URS services, and as you can see here in this data from 2014 to 2015, actually the number of URS complaints has slightly decreased, despite a significant increase in the actual number of the domain names registered under the new GTLDs. So just to give a quick example of some of the disputes that have arisen in the banking and financial services industry under the URS, all of these entities on the screen here, Morgan Stanley, PwC, and Bank of the West, have filed URS complaints in the past year or so. So as you can see, these are all with respect to new GTLDs, .global, .accountants, and .money. Obviously, top-level domain names that have a particular correspondence to the banking and financial services industry. And in all three of these cases, these domain names were suspended by the National Arbitration Forum. In the case of the Morgan Stanley .global dispute, this was just an inactive domain name. It was not being used in connection with any type of phishing activity or so forth. Nevertheless, the URS panel suspended this domain name. The PwC, PricewaterhouseCoopers case, again, .accountants. This is one of those interesting cases, domain name dispute cases, where the top-level domain may have some particular relevance to the dispute itself. For many years under the UDRP, UDRP panelists would say that the top-level domain name is irrelevant, .com, .net, .org, for example. But now the top-level domain name may be relevant, and so PwC.accountants, for example, perhaps convey something quite different than PwC.xyz or PwC.club or .guru or any of the other of hundreds of new top-level domain names that have been launched. In this case, the domain name not only contained accountants as the top-level domain, but the domain name, as the URS panelist said, was used to redirect to a web page containing links to third-party accounting firms, obviously in direct competition with PricewaterhouseCoopers. And some of those accounting firms were competitors of PwC. So in that case, the URS panel suspended that domain name as well. And then finally on the screen, Bank of the West, based in San Francisco, filed a URS complaint for bankofthewest.money. In this case, the URS panel or expert said that the GTLD.money certainly indicates the kind of services that banks provide. And also, there was evidence that was a part of this URS proceeding indicating that the registrant of the domain name actually had registered it with the intent of selling it to the complainant. There was a little bit of this interesting back and forth that cybersquatters and trademark owners often have about whether the domain name is for sale or at what price, but ultimately the URS panel did find bad faith under the URS and ordered that domain name suspended. Interestingly though, not all URS cases are straightforward. As I said before, they're really only appropriate in certain instances. And this is one of those cases in which a company in the banking and financial services industry actually lost its URS complaint. This is a dispute filed by the Prudential Insurance Company of America, not for a domain name containing Prudential, but still for one containing a registered trademark that it owned, and in this case for the trademark Rock Solid. The .financial certainly indicates that perhaps there's an association between the domain name or a website that might be launched with the domain name that is related to the financial services industry, although today this domain name, despite Prudential's failure to obtain a suspension, this domain name is not associated with an active website. At the time of the dispute, it was connected to a parking page. But as you can see here, the URS expert actually said that there's a consensus view that the mere registration of a domain name, even one that is comprised of the confirmed dictionary word or phrase, may not of itself confer rights or legitimate interests in a domain name. The URS expert set out some limits that we've seen in some other URS cases in which trademark owners have been unable to prevail in their proceedings. And then finally, just one more quick screen slide before we move on to some of the questions and answers that I think we have in the queue. With the rise of the new top-level domains that we've been talking about, the URS is not the only dispute policy that applies. The UDRP also applies to the new top-level domains. So in the case of all of these domain names that you see on the screen here, these were all UDRP complaints filed by trademark owners in the banking and financial services industry, all in different types of usages. The Comerica.mortgage, for example, simply redirected to a website that talked about the benefits of owning descriptive top-level domains. The UDRP panel didn't buy it, so to speak, and ordered that domain name transferred. Dollar Bank loancenter.xyz. .xyz, I mentioned earlier in passing, is actually proven to be one of the more popular top-level domains, perhaps because of some attention that was given to it by Google and Google's parent company Alphabet, which is using the .xyz domain name itself. But in this case, the registrant of $bankloancenter.xyz was actually redirecting it to a website that made it appear as if it was associated with a reputable bank when it was not. Similarly, you can't have a presentation about domain name disputes without talking about the adult industry or pornography, and sure enough, financial services entities and banks have faced this problem for years and are facing it now in the new top-level domain names as well. For example, citibank.porn. I don't believe that there was actually a pornographic website associated with the domain name. The domain name was inactive at the time of the dispute. There was just a page that said that a website was coming soon. But in that case, Citibank actually argued that the registration of its trademark, Citibank, in connection with the .porn top-level domain somehow tarnishes the Citibank trademark, and the UDRP panel agreed and ordered that domain name transferred. I want to leave the rest of the time for questions and answers, but as you can see, the Hancock Bank online case and tdbank.email case, .email has been a popular top-level domain name with a lot of UDRP and URS disputes under it, including those in the industry that we're talking about today. So all of these domain names have been transferred to their trademark owners. So at this time, I know that some questions have been submitted as we've been going, and Craig and I are happy to take those. I think Carol has been collecting some of them, and as you can see, you can enter your questions online at any time, even while we're speaking here now. And while Craig and I are fielding some of these questions, we'll go ahead and just show you some of the resources that Craig was referring to earlier, where you can learn more about some of these important issues.
All right, thank you both. Good presentation, and we do have a number of questions that have come in. Craig, the first one I'm going to direct to you. If so many banks have registered they're under the new domain, why aren't more of them using them actively and promoting them?
Good question, Carol. And so far, we've seen several hundred banks activate their domain names. The success stories that we included on the slides were just obviously a snapshot. But what we're hearing from a lot of banks, and we talk to them regularly, is some are tying the launch of their .bank domain to perhaps the launch of a new website, the launch of a specific marketing or promotions program. Some are also waiting until they make major changes with their key vendors. So there are lots of reasons to time the launch of .bank to something operationally that the bank is undertaking. We also hear from a number of banks that they are waiting to see about what the uptake will be on .bank and are looking to see what their competitors are doing before they move. So there are a variety of reasons, and part of our purpose in publishing these success stories is to share that it's just overall a lot easier than banks, I think, have expected, and that will give them really helpful information in order to develop their plan and make the change themselves.
Interesting. Thank you. Doug, I'll direct this one to you. A question came in, it's kind of a two-part question. What about the domain .sucks and cybersquatting related to those domain names? Are you seeing an increase in cybersquatting or bad actors using or registering those kind of domain names to essentially ransom the trademark holder? And does that trademark law or the expedited process mentioned earlier help in these instances?
It's a great question. I'm not sure I understand the last part of it, but I can certainly talk to the question generally. And what's interesting here is, what Craig's company has done is a great service to the banking and financial services industry, because it's sort of created this sacrosanct space. But unfortunately, nobody can eliminate all of these issues entirely from the internet. I think we saw something very similar with the launch of .XXX a number of years ago, there was, prior to its launch, which was quite controversial, there was a lot of discussion about what impact that would have about the availability of adult-oriented sexual or pornographic content on the internet in general. And it was clear that .XXX would ultimately be a place where you could certainly find that content, but it probably would not do anything to remove the content from other places online. Why am I talking about that now, and what's its relevant to the banking and financial services industry? I'm saying it because of the question about .sucks, which is despite the creation of new top-level domains like .bank and .insurance, and which have these great registration criteria, as well as the other new top-level domains that Craig had on his screen that are certainly appealing to the financial services industry. There's nothing against the cybersquatters from registering a trademark that is identical or confusingly similar to somebody else's trademark in any of the new top-level domains, such as .sucks. Now, .sucks is one of the more interesting and controversial examples of new top-level domains, but I think that the banking and financial services industry are probably just as likely to see issues under .sucks as anybody else is. And frankly, despite a lot of the concern with respect to some of the registration rules and pricing with respect to .sucks, I frankly have not seen a significant amount of interest among trademark owners in pursuing cyber squatters who have registered .sucks domain names at this point.
All right, thank you. Craig, this one's back to you. How many insurance companies have you seen file for the .insurance registration now? And are you seeing that banks may also, or can they, in the registration and verification process, register both .bank and .insurance?
So the first question about .insurance, given that TLD just launched on May 5th and we're just in the first couple of days of sunrise, we've seen about 100 registrations in the first couple of days, and are hoping that we have an equally strong sunrise period in .insurance as we had in .bank. And Carol, the second part of the question is, can a bank register an insurance name?
Yeah, the question was, can they are they eligible to register both .bank and .insurance if they have an insurance arm?
As long as the bank has an insurance arm that is overseen and supervised by an insurance regulatory authority, they can certainly register a .insurance domain name.
Interesting. This may be for you, Doug. What are the penalties for not complying with domain name suspension orders?
Well, fortunately, if by suspension orders the question is referring to the URS, which is that dispute policy that allows a domain name to be suspended, the registry operator is actually required contractually to carry out the URS determinations, is what they're called, actually not decisions. And so if there is a URS determination that a domain name be suspended, then the current website, if there is one, or the inactive website, if there's not one, is simply replaced at the registry level with a suspension page that says this domain name has been suspended pursuant to the URS proceeding. So it's really, there's really nothing further that a trademark owner has to do after receiving the URS determination, unless it goes through the appeals process, which has happened in a number of cases. But otherwise, the most difficult challenge was in some of the very early URS decisions. As I said, the policy itself is only a couple of years old. In some of the very early decisions, the registries and registrars were kind of uncertain what to do because nobody had ever implemented a URS decision before. But now that we've seen a number of them, not a large number, but now that we've seen a number of them, it's for the most part working as it should, and those suspension pages are popping up typically pretty quickly.
All right. Well, that brings us to the witching hour of 2 o'clock. We wanted to stay on time, and just want to thank you both for your presentation today. We will be sending out the evaluation form shortly to everyone. We would ask that you please stay on long enough to complete that and indicate on there whether you would like to receive copies of our presentation today, and we will be happy to email those out to you. We thank everybody for participating, and this will conclude today's webinar.